The record reflects we are back in session. Parties of council are present. Members of our jury are present, and we have our witness, Mr. Shogren, back on the stand. And Ms. Rodriguez, you may continue your examination.
So one of the things that you had testified about yesterday, to be clear, you testified that you had reviewed Joseph McStay's bank records, right?
Yes.
And the defendant's bank records, right?
Yes.
And you testified that there were transfers or money deposited into Joseph McStay's bank account by the defendant. Do you recall saying that?
Yes.
And can you show me where in the bank records you actually saw that? And if I can just come up and see what you're looking at.
So this would be one Earth Inspired Products, and that's a Chase Merritt signature or initials.
So
this is a deposit slip.
You think that is, but you're not sure.
Well, I'm not a handwriting expert, but it says CM.
Okay. And where else did you see that money was deposited by the defendant into the Earth Inspired Products account?
So here's there are two more that I happen to have with me.
Okay. And what is it that leads you to believe that this is a deposit into that particular account?
Well, it says deposit Earth Inspired Products. There's an amount and the initial CM again.
And did you verify that with the actual bank account?
I'm sure we did. I don't have a copy of that page with me. I don't have a copy of that statement with me.
Okay.
And again, Earth Inspired Products, deposit slip, checks totaling 12. There's a series of checks here, and again, initial CM.
Does that initial appear to be the same initial that you observed on the other deposits?
Oh no, you know right. That actually looks like it is slightly different. So
And
that one may not be.
Okay, so you're just assuming that because that initial is there, that that's a deposit from the defendant?
Well, somebody has initialed that and made that deposit, and yes, that is an assumption that we made. Seems like a reasonable assumption.
Did you do anything to verify, because those look like a couple of checks on the back there, right,
Mm-hmm.
that are listed?
Mm-hmm.
Did you do anything to verify when you looked at Mr. McStay's bank account records to determine if those were actually checks from the defendant that were deposited?
I don't know. I don't remember that we verified who the checks were from. What I believed that I testified to was that he made deposits into the account, not of his own checks. I don't recall that.
Okay, so you believe that the defendant actually deposited money into Joseph McStay's account, but it wasn't money from the defendant to Mr. McStay?
I don't recall verifying that.
Okay, because at this particular time, the deposit that you're looking at is November 30th of 2009, right?
Correct.
And at that time, you did not have any bank account information for the defendant, right?
That's correct.
So he did not have a checking account in order to write checks to deposit into Mr. McStay's account at that time, right?
I don't know. We didn't have copies of. If he had an account, we didn't have a copy of it.
Okay, so you would want to have all of that information, though, before you would make a determination that that was actually a deposit from the defendant into Mr. McStay's account, right?
Objection, it misstates his testimony.
Overruled. You can answer if that's correct.
So no, that's not what I'm testifying to. What I said is that this was a deposit that he made. What I said is that I don't have a copy of these. At least I don't remember seeing a copy of these checks. But again, I don't have all those checks. So.
And maybe I can borrow that for just a moment, and maybe one of my associates can look in Mr. McStay's account to see if those were deposits from the defendant.
Your Honor, the witness didn't testify there are deposits from the defendant. There are deposits he made, but not, I mean,
Overruled.
Okay, so while he's looking that up, you had testified yesterday as well that, and I think you created a schedule that the average that the defendant received, this would be exhibit 1125, put on the overhead here. The average the defendant would receive for each particular job was somewhere in the neighborhood of 65%, right?
That's correct.
And that would verify depending on whether or not, well, I mean, there would be different circumstances where that varied a little bit, right?
That's correct.
Okay, and so you indicated that at some point there was a change in that business relationship, right?
There was a change in how the funds from the projects were shared, that's correct.
Okay, and showing you page 3 of that exhibit that you created, we see down at the end here, starting around October 2nd of 2009 with this Carol Elkind, that percentage the defendant received was 16%, right?
That's correct.
And then there were several other jobs where his percentage was lowered significantly, right?
That's correct.
And it's your opinion that that was because Joseph McStay had started paying Metro Sheet Metal, right?
That's correct.
Were you aware, or did you have any facts to indicate to you? I know that you looked through the records and you didn't see any records, unless are you looking through something different now?
I'm just looking at the ledger that supports this, that
Okay.
came off of.
Did you have an
Your
opportunity?
Honor, I don't think it's proper for the counsel to just constantly ask what he's looking at. I mean, she can ask a question.
Overruled.
Did you have an opportunity, I know you looked at some checks before we went on break, to look to see if there was any checks to Metro Sheet Metal, right? Is that correct?
That's correct.
Did you have an opportunity to review any additional records to see if there were any other payments to Metro Sheet Metal from the defendant's bank account?
Yes, in fact, what happened was I misspoke and was referring to checks that had been credited to the defendant as if he had written them in this time frame. And so that's what I have.
Okay, so
And
the
I could show you on the ledger where those are reflected.
that's okay, so
Your Honor, the
Those
witness
would
can
be-
explain and show the counsel and the jury what
You
he's
can do
talking
that
about.
on redirect.
So you had an opportunity to look, and those checks were actually payments that were made by Joseph McStay, right?
They were made by Joseph McStay on behalf of, or in place of Chase.
Okay, but you don't have any information before you that the defendant actually had written checks to Metro Sheet Metal, right?
That's correct, and we went back electronically and looked at those, searched those, and actually didn't find any. So that was a confusion on my part between what happened before and after that date in October.
Okay, and so when you look at the information that you have, do you have any information or knowledge as to whether or not the defendant actually, when he was receiving that 65%, going back, I think your chart goes back to 2000 and, is it 7 or 8?
2007.
And so when he was receiving that 65%, it's your understanding or your opinion that he was actually making, or he was paying for some supplies and manufacturing and things like that, right?
So yes, it's my understanding that he was buying some supplies, and it's my understanding that he was the principal manufacturer. So he was not utilizing the services of Metro Sheet Metal at the time because he was doing the fabrication.
Okay, so if he was doing the fabrication and then Metro Sheet Metal took over the fabrication, that would be a loss of income to him then, right?
Yes,
Okay, so you testified that initially he was getting 65%, right?
I did.
And that the average then dropped down to 15%, is that right?
That's correct.
So how much of a loss of percentage of income would that be to the defendant?
I don't have a way to answer that because I don't know how much work he was doing at the time.
Well, if you calculate it, it comes out to around a 77% loss of income. Does that sound about right?
I have no idea because I don't know that this is his only source of income.
Well, you had the opportunity to review the defendant's records, right?
That's correct.
And in those records, did you see any other deposits or any other checks or source of revenue that was attributed to somebody other than Earth Inspired Products?
I did not, but it's not sufficient to overcome the idea that he might have received cash for things.
Okay. But you didn't see any other checks that were made out to iDesign or anything like that, right?
I did not.
And in fact, you testified and you wrote in your report that in May of 2010, the defendant effectively went out of business, right?
Yes.
And that was because Joseph McStay was no longer around, right?
I'm sure it had some influence. I don't know why he stopped doing business.
Okay. Well, you don't have any other way to attribute any other source of income to the defendant other than Earth Inspired Products, right?
I've not looked at anything that reported that income.
Well, you wanted to make sure that you were thorough in your analysis, right?
That's correct.
And you wanted to review all of the records to make sure that you presented a thorough picture, right?
And so we asked multiple times to make sure that we had all the records, and just a week ago we found out about 2 accounts that belong to Joseph McStay that we'd never heard of before. So the fact that we didn't get something doesn't mean it didn't exist.
So my question to you though is, sir, that information would have been important in determining and doing an analysis of the defendant's financial picture because you want to make sure that you provide an accurate picture of the defendant's finances, right?
That's correct. And we requested it and assumed that we received everything that was pertinent. It's clear that we didn't for everybody.
Okay, well, you didn't receive anything additional for the defendant, right?
That's correct.
Didn't receive any bank accounts for December of 2009, November of 2009, and January of 2010, right?
That's correct.
Didn't get any bank information for after May of 2010, right?
That's correct.
Didn't look at any records or ask for any records related to Catherine Jarvis, did you?
We did not ask for her bank statements. We did note in our analysis, included in our analysis, when checks went to her, and we included that as receipts for the defendant.
So you were aware of the fact that she was receiving money on behalf of the defendant?
We did know that, yes.
But you didn't ask for those records as part of the information in this case?
I don't recall ever seeing a series of bank statements from her, no.
Okay. And so if the defendant had been making 65% before that and was reduced down to 15%, that would be a significant loss of income, right?
That would be a significant loss of income, but he was not limited to the 15%. You'll remember both Saudi Arabia and Paul Mitchell included other amounts than just the 15%.
Well, you testified earlier that there was a change in the business model, right?
That's correct.
And it appeared that Joseph was outsourcing some of the welding and Metro Sheet Metal was doing that, right?
That's correct.
And that would be a loss of income to the defendant if he was no longer performing that activity for Joseph McStay, right?
It would be, but it would not be fair to say that it was a straight line. If you look at this that's on the board, you'll see that during that time, just in November, it went to 55% on that project and 63% on this project. So this is not consistent at 15%. It can be more than that, substantially more than that in some cases. And we are aware of at least 2 projects that included significant amounts more than the 15%.
Okay, well let's talk about some of those projects because the majority of the time when the defendant received money from Joseph McStay, he didn't typically receive it all in one lump sum, right?
The ledgers show that he received that money in multiple payments, occasionally one payment, sometimes 2, 3, and rarely as many as 4.
And that was usually if it was a smaller amount, right? If there was a one-time payment? Can I see what you're referring to, sir?
So I'm looking at the ledgers again.
Okay, and do you have the 2009 ledger in front of you?
I have 7, 8, and 9 here.
Okay, and so the 2009 ledger, if we look at it, Britt, do you think you could pull that up on the overhead, please? Is that this one here?
It is.
Okay.
Mr. Jackson, go to my computer, please. Thanks, sir.
Okay, and then going down to the bottom where we see that change in the percentages, if you can zoom out a little bit, we still see payments broken up into multiple payments, right?
That's correct.
Okay, and do you know, or did you do anything to go back and verify with respect to the time separation between those payments? Like, was one of them a final payment when the job was completed? One was an initial payment to start, maybe additional payments in the middle?
We didn't look at the time between those payments, but when there were multiple payments, that's an assumption. That's a reasonable assumption. If I can get you to go to the top,
Okay,
so that we can just see here, when Joseph did this schedule, he had only 2 columns for payments to Chase.
right,
And then he had a balance, and then he had payments to Metro, so the payments to the right from Metro on are not to Chase, and only the first 2. And these, in fact, are relatively small payments. There's limited number of payments that are made under this scenario on this. If I can get you to go back to either 8 or 9, we could look at both of them, you'll see that there are occasionally 1 and sometimes 2 payments.
well, it's okay, we saw on that particular exhibit, there's sometimes 1 and 2 payments on there, right?
There is a significant difference because in 2009, if we could have that back, so you'll see that the top part of this, the January through September, it hasn't been filled out yet. So this ledger is not complete for those payments. So we're looking at a small snapshot when we refer to only the bottom part of this. That's why I went back to look at the prior years. And there are a significant number in 2008. It looks like it's nearly half of them would have been paid in one payment.
Okay,
Maybe only a third of them in 2007, but it's not fair to say that they were all spread out and only small payments made.
okay, well, you would agree that you testified that the way that Joseph worked in his business model was that he would receive 50% upfront, right?
Yes?
And then the remaining balance upon completion of the project, right?
Upon the completion, I think that it was also terms upon shipment, so
Okay, and so sometimes that would include installation, right?
that's correct.
Okay, and so he wouldn't actually receive the final monies until the project was either shipped or installed, right?
Shipped or installed, I think that's a correct statement.
Okay, and on some of the bigger projects that you looked at from 07, 08, 09, the payments to the defendant would have been spread out, right?
Yeah, I'm looking at 2007, and the large majority of those payments were made in either 1 or 2 payments. There's just a few stragglers that drug out beyond that.
Okay, and you prepared this exhibit, going to the overhead, 1115 on Saudi Arabia, right? This was an exhibit that you had actually prepared just the other day, right?
That's correct.
And this exhibit details or talks about the payments that were received with respect to the Saudi Arabia job, right?
That's correct.
And it starts off with, you went through QuickBooks, right, and you reviewed that information. There was an invoice in there for $61,542.50, right?
The invoice, there was 2 invoices for half of that, so we know what the total was. We know what the total sale was, and then only $30,771 was invoiced to start the project.
Okay, and yesterday when you testified, you indicated that you weren't able to see all of the information in QuickBooks initially, right?
That's correct.
And you were able to, though, when you went back and you looked through the records that you received initially, you were able to see information about the Paul Mitchell job, right?
We found this level of information in the clones that we received just a few weeks ago, 2 or 3 weeks ago.
Okay, and
That's
so,
where we got the invoices from.
okay. Well, you had an opportunity to review the initial information in the QuickBooks accounts, right?
That's correct.
And that included detailed information about customers and accounts and things like that, right?
Very difficult to decipher. So we really appreciated access to the clones because we could now get actual copies of invoices.
Well, you indicated that you had followed up with defense counsel numerous times about additional things that you needed information on, right?
Yes.
And when did you ask them to give you the copies of the clones that they had received?
My understanding is that he gave them to us as soon as they had access to them.
Okay, so if they had the clones prior to that and you didn't receive them, then you would not have included that in your analysis, right?
That's correct.
And so when you did your initial report in this particular case, you did a breakdown of the actual amounts related to EIP and this particular job, right? The Saudi Arabia job, do you recall that? Would have been on the second to last page of your report. And it was labeled Perspective on Payments from Saudi Arabia. Do you see that?
I do.
Okay, and in there you had payments to the parties, and you had Mr. McStay receiving $30,733, which we see reflected on there, right?
Yes.
And it had Mr. Kavanaugh receiving $16,839, right?
Yes.
And you had Mr. Merritt receiving $13,862. Is that correct?
That's correct.
But what you didn't include in that initial analysis was the fact that there were multiple checks written to the defendant that were labeled or discussed in terms of being Saudi Arabia payments, right?
That's correct.
And then you redid this chart and you included that information in this chart, right?
That's correct.
Okay, so your initial report would have been off because Mr. Merritt got that $13,862 deposit into his account as well as these 3 checks, right?
That's correct. We certainly did not produce this report as an end-all report. It was a status update on where we were. We continued to get a lot of information after the date of this report.
Okay, well, to be clear, you did have that information on those checks, right?
We may have, but yes, we would have had those checks.
You would have had those checks because you had the defendant's bank information, right? Or so you show those checks being deposited into the defendant's bank account, right?
We do.
And you also show you had Mr. McStay's bank records, right?
Yes.
And you would see in there that those particular checks had actually been written out of that bank account, right?
That's correct.
So that wasn't new information when you drafted this report, right?
That was not.
And you didn't include anything here on your perspective on payments from Saudi Arabia. You put in a couple of wire transfers, the wire transfer that Mr. Kavanaugh received from Kokoshe, right?
Yes.
And you didn't put anything in there about the money that he transferred that we talked about earlier, that $10,700 to Metro Sheet Metal, right?
I didn't put it in this, but it was included in our cost of goods sold analysis.
But you didn't put it in here to reflect that that was actually extended to Metro Sheet Metal for that project, right?
That's correct.
And of that amount that we see here for the defendant that he received, that $13,862 plus that $11,345, how much of that were you able to track that was expended for the Saudi Arabia project?
Off the top of my head, I can't answer. I don't know the answer to that question.
So you don't have any information as to how much the defendant spent on the Saudi Arabia project based on those records?
I don't know off the top of my head. I don't have a report with that on it in front of me.
All right, let me interrupt you at this point. It's about 4:20, so we'll go ahead and take our evening recess at this time until 9:30 tomorrow morning. We'll see everyone back at 9:30 tomorrow morning. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case, and we'll see everyone back at 9:30 tomorrow morning. So, we're back on the record, parties in council are present, our jurors are not present. We've gotten several requests from jurors indicating they're not gonna be available, into May. So here's what I have so far. Monday, May the 6th, I indicated I'm not gonna be here. Thursday, May 9th, one of the jurors cannot be here in the morning. Thursday, May 16th, and Monday, May 20th, two jurors are off because of a weekend cruise.
Can we go with them?
So, and then the DA's indicated some of you are gonna be gone during a period of time?
It's the week of the 13th that's gonna be problematic.
I can accommodate.
Well, and again, the question is, what is going on,
Right,
whether it's a problem or not? If we're scheduled to do closing arguments on the 14th or 15th, that's gonna cause a problem. If we're
not
still,
if you waive your argument.
since when have you ever known a lawyer to waive an argument?
If they're not here and can't do it when it's scheduled.
So, anyways.
Somebody can fill in.
But if we're, for some reason, still taking testimony, I don't know, so it's kind of fluid.
Alright, I'm just telling you where we're at, and, you know, we totally qualified the jurors through April, so now that we're into May, you know, when they said they had issues in May and June, we said, don't worry about it. Well, those are starting to create problems. And the further we go, the more problems we're gonna have.
I don't know how much more the defense has. I think we have one or two rebuttal witnesses that'll be less than half a day.
Well, I've heard that. So, we'll see. I'm just telling you that we're starting to run into problems where we could start losing jurors.
Right, that's what happens when we take a month off.
Well, we took various times off for various reasons.
if we can get an indication, I know Ms. Rodriguez is pretty close to finishing with Mr. Schoenberg, who we have coming next. We have 3 witnesses they've asked for on call, waiting, so we haven't been given an indication of when they need them, who's next.
Some of those things I think we could stipulate too as well to speed up the
Yeah, well,
process.
you guys can work that out between you, I mean, that's fine. I was under the impression based on the representations made last time that Sjogren and Rudin were the last witnesses.
I believe that's accurate, but for law enforcement. So we have,
But for,
but for law enforcement, those are the 3 on-call witnesses they're talking about. And Your Honor, if you remember, we still have the issue that one of the witnesses is Bachman, Sergeant Bachman, regarding the interview with Mr. Merritt. And we have to do that hearing on what the court is gonna allow us to play of that, because that's the 8-hour or 7-hour interview.
well, that was the one that you originally were going to indicate what portions you wanted to play, and then I would look at it.
Correct. We have a redacted version, which includes the redactions for all of the references to anyone regarding polygraph, whether the officers are talking about it or whether Mr. Merritt's talking about it. Those have been redacted. Other than that, we're okay with everything else to come in. I think it's the prosecution that wants to maybe have a look at that and maybe further cut it down.
So we can deal with that now. It's 356 issue. The court has our pleadings. They're asking to play the entire thing absent reference to polygraph. We're arguing that under 356 they're not entitled to. And the court gave it indicated last week.
Yeah,
So I think to make some clarity, why don't we deal with that issue now?
if I remember correctly, the portions of that interview that the prosecution played had dealt with Mr. Merritt's whereabouts on February the 4th and February the 6th.
Only the 6th, actually.
Only the 6th?
Yes.
Okay, I'd have to look at that. So obviously, if it was the 4th and the 6th, anything that goes in the rest of the interview that goes to the issue of his whereabouts on those dates would be admissible under 356. Other subjects would not be admissible.
And I would definitely agree with the court's thinking on that, except for the fact that it's not just the interview that we want the court to consider, that the portions they played of that interview. I believe the statute is pretty clear. It's any recordings they played of any, whether included, whether it's the jailhouse interviews or the jail calls or whatever. It's not just limited to that interview. We're allowed to play the portions of the interview that clarify all the statements that they've introduced, not just from that interview.
That is not true. There's no authority for this.
It's in the statute.
So you're saying if they played part of a conversation, either an interview or conversation that Mr. Merritt had on occasion number 1, and then either months or years earlier or later, in a totally different conversation, he said something that relates to that first one, the earlier or later statement comes in?
If they played it. And I think it's actually in the statute itself, Your Honor, so.
You'd have to show me some authority on that. I mean, it's an interesting idea,
The
but
case law is very clear that it's conversation specific.
in the same conversation.
Yes.
That's been normally my understanding, but
I mean, we briefed it for you, Your Honor.
but I've never had that come up where someone says, well, we have conversation number 1, and then the subject in conversation number one came up in conversation 9, and so we wanna play conversation 9 to explain what was said in conversation number 1. I don't know that you can do that, but I don't know that you can't either, so,
We have points and authorities that we're filing today on that, so the court can take a
I'll
look
be
at them
happy to look at them.
You got it?
tomorrow.
Okay, Okay.
But Your Honor, so in terms of scheduling, just so the court knows, we have however long Mr. Sjogren takes. And
so I
then
figure Shogun will take tomorrow and Thursday. After redirect, right?
And redirect? Okay.
Sure.
Yes, but whenever Mr. Sjogren finishes, our plan is to go to one of the 3 on-call witnesses. I think Hart would be the first one, which is relatively short, and then we have Steers. And then we would go to Sergeant Bachman after that.
So Bachman's as to the statement.
Yeah, Bachman is sent to the statement.
So we have to resolve that issue first.
I think the court just made a ruling.
Well, I didn't make a ruling, I indicated what my basic understanding is right now, but I'm more than happy to look at any authority from both sides as to whether or not a statement in one conversation opens the door to a statement in a totally different conversation at a different time to explain the first statement. I don't know the answer to that.
I do.
Never looked at it.
Well, we actually, some of the witnesses he just indicated he had planned on calling tomorrow are actually not available tomorrow, so who's not available?
And they told him that last week when they were here.
Okay, well,
Actually, what's today?
if any of them are available, maybe they can be here in the afternoon
We
tomorrow.
we'll reach out to them and have them here if we can.
In the afternoon, I would say.
Yes, definitely in the afternoon.
I mean, Ms. Rodriguez isn't even finished with Cross yet, I assume, Mr. Moline will have some redirect, and it might be possible that Mr. Rodriguez might even have some recross after that. So, I can definitely see Mr. Sjogren taking all of them, at least all of the morning.
I agree.
Maybe they can be on call for the afternoon and we can call them at the noon recess to let them know, what it looks like at that point.
That's fine.
Okay?
That's fine.
All right, thank you.